Okay, we are now in week 5 of your workers' comp, social security, and bankruptcy class. We are going to continue with bankruptcy, chapter 7 in the text, where we're going to start going through the means test and looking at the chapter 7 bankruptcy petition specifically. Now, just to review, we've gone through all the different kinds of debts that are available to us: the consensual, the non-consensual, the secured, the non-secured. We've gone through liens and how to collect a debt and the limitations from the Consumer Protection Act, Credit Protection Act. We've gone through basically the introduction to why we have bankruptcy laws, the rich history we have in having relief for people who need it financially, but balancing that with the needs of the creditors to be repaid. So we're in this balancing act. We've gone through the fact that we have a bankruptcy trustee who is appointed by the bankruptcy judge, who is a federal judge, who is appointed for 10-year terms. And the bankruptcy trustee protects the interests of the creditor and shepherds the case through the system. We've gone through the fact that there are different kinds of bankruptcy relief that are available to different kinds of petitioners: farmers, municipalities, people who want to liquidate everything and start over, and people who want to reorganize their debts, for businesses and for consumers, individuals who we call consumers. So we're going to focus in this lecture on Chapter 7 of the Bankruptcy Code. Chapter 7 is a liquidation chapter for both individuals and for businesses. What does that mean when I say liquidation? Liquidation means you're going to take your assets, you're going to sell them, you're going to liquidate them, right? When you liquidate an asset, you turn it from, or convert it from, what it is to money. If I liquidate my assets, I'm going to take my house, my furniture, my cars, everything I own, I'm going to sell it, and I'm going to have cash. Okay? So there oftentimes is liquidation in a Chapter 7 case, where you go to the court and you say, look, I'm filing this petition. There is no way I can pay these bills. I have minimal assets, and the trustee will look at those assets and say, well, you don't have much, but you have this. We're going to sell it. You've got a gun collection. We're going to sell it. We're going to raise some money, and then we're going to distribute that money to the creditors. In a lot of Chapter 7 cases, people don't have anything. Those are called no asset cases. Those are the easiest cases to do. They just are. There's nothing there. The creditors are going to get nothing, and you're finished. By the way, you can liquidate a bank account. So if I have $10,000 in the bank, except for a small amount that the court is required to give me as an exemption, that money is going to be distributed amongst my creditors. Okay? Now, before you can even get to the point where you're going to file for a Chapter 7 bankruptcy, you have to meet the means test. What does that mean? Well, there are qualifications that Congress came up with in its revisions to the Bankruptcy Code. And it starts with Section 109 of the Code, that says basically that no individual, either individual or business, may be a debtor under any chapter of the Code unless within 100 days before filing its petition, which is defined as being pre-petition, the individual receives an individual or group briefing by phone, internet, or with a credit counseling agency that outlines the opportunities available for credit counseling and assists the individual in performing a related budget analysis. What does that mean? That means that 180 days. How many months is that? 6 months. before you file for bankruptcy, right? About within 6 months of when you file for bankruptcy, you've got to go to an approved provider of credit counseling. It can be on the internet, it can be in person, that will tell you, you don't really have to file for bankruptcy. We can rejiggle your loans. We can consolidate your debt into one payment. We can find a ways for you to avoid filing for bankruptcy. Why do we do that? Well, lots of reasons why Congress did this. Number one was people were just filing bankruptcies. The 1990s was bankruptcy palooza. We partied like crazy in the 1980s and early 1990s, and by the end of the 1990s, everybody was having a hangover and had to file for bankruptcy. And the courts were like, what in the world's going on? It used to be nobody wanted to file for bankruptcy. There was embarrassment. There was a willingness to try and negotiate one-on-one with your creditors so that you don't have to come through this process. We don't want people to have to file for bankruptcy. And then there were also, besides just the people who were just filing because they could, and we also had lawyers that were kind of cashing in. Again, the 1990s were, 80s and early 90s was a party. And people's bill became due, and bankruptcy lawyers sniffed out the opportunity to file for bankruptcy. Bankruptcy lawyers were getting rich, and they weren't always as scrupulous as they should have been. And they may have filed cases that shouldn't have been filed. And so what Congress said is, look, we're going to not tell people you shouldn't file for bankruptcy, but we're going to encourage them to find another way to deal with their credit and debt issues. And so you are required within 180 days to meet with an approved nonprofit budget and credit counseling agency. How do you know what those are? Google it, they'll all say, we are approved. It's also like a little cottage industry. So agencies will go out there and specifically get approval to be a budget and credit counseling agency, and then, they get tons of business. So that is our first step in this process. Okay, so that's the first step in our process. The next thing that we have to do is a Section 707B means test and presumption of abuse limitation. What in the world is that? This isn't primarily for consumer debts. This is not so much for businesses. And what is a consumer debt? A debt incurred by an individual primarily for the personal, family, or household purpose. So if I have a basement business and I'm not incorporated, it's just my thing that I go and I do on weekends, any debts that are associated with that are not subject to this means test, okay? Now, the interesting thing about this means test, it is before you even start, there's a presumption that you're abusing the system. Again, left over from the 1990s hangover. The presumption of abuse is that you are not going to meet the means test. It's kind of a big deal. So what is the means test? The means test compares if you're the debtor, your average monthly income and expenses to everybody else in your region of the country. Now, we don't compare you to people in New York, if you live in Ohio or California. Cost of living is different there. Income is different there. If I live in New York City and make $100,000, I'm scraping. If I make $100,000 here in Niles, Ohio, not doing too badly. Okay, so we compare your monthly income to the monthly income of people in your region. How do we know what people in your region make? Well, the U.S. Census provides that information. It's put together, and that's how they come up with what the regional money or regional income is. Okay? Now, you cannot file for Chapter 7 relief unless you satisfy this means test. And what we do is we look at your income. And we will include wages, salary, tips, bonuses, overtime, and commissions, your gross income from a business, if you run the business, interest, dividends, royalties. If I have stocks and I've invested in and I get paid dividends, that gets included in my income calculation. Regular child support or spousal support, which is kind of a big deal because that was usually off the table, but it's not when we do our income calculation. Unemployment compensation, pension and retirement income, workers' comp payments, annuity payments, and disability insurance payments. So we are taking every bit of money that you get, and we don't care where you get it from. And that's how we're going to look at your income. However, we are not going to look at your tax refund. That will not be part of your calculation. Social Security retirement benefits, Social Security disability insurance payments, supplemental security income payments. You're going to learn about all those at the end of this chapter. And temporary assistance for needy families, so if you get some welfare benefits. Okay? So we're trying to figure out whether you actually have enough money that we actually could restructure your debts under a Chapter 13 or a Chapter 11 if you're a business, but this really doesn't apply to businesses, or whether we really don't have the money to satisfy paying your creditors. Okay? So what is this means test? How do you do it? Well, you're going to use, there is a calculation form. And in my book, it's on page 217. It's illustration 7-A. So we're going to add up all of your income, and we are going to look at whether the means test applies to you. If you are below the median income in your region, you're okay. You pass the means test. Most people actually do pass the means test, believe it or not. If you are above the monthly income, you can actually say, look, we have a deal where we can ask for an exemption. We can say, hey, you know what? We have extenuating circumstances. We have someone who was sick. We have other issues. Now, the full calculation of the means test is on page 231, illustration 7-C. And your book takes you step by step through this calculation. Now, I'm going to tell you that if you do bankruptcy law, you have a software program and you plug it in. It's part of the bankruptcy software program. If you have trouble with the presumption, if you don't meet the means test, if you don't fall below the median income in your area, you can show special circumstances. Again, you can show that there are issues that you need to cover so that you can get rid of primarily medical bills. That's usually the big deal. Okay? Honestly, if you can understand the terms of this chapter, then, and if you have the software for it, you're in good shape. That's really all you really need to know about the means test, except for if you are going to challenge the means test, and the attorney will do that. So you don't have to worry about that. Okay? I'm going to ask you to read through the example of Marta and go through this this particular means test so that you can answer some of the questions. So this will be a shorter lecture than normal, but the reason why is you're going to have a lot more time to put into the review questions that I've assigned for you already. And remember, you're going to use the fact pattern that is in your book and the example that's in your book to go through to answer these questions. If you have any questions or concerns, please reach out to me. I'm happy to go through the means test with you. I don't want to spend a ton of time on it because I would rather get to how to fill out the petition, which is what your next module is about. And honestly, the means test, it's all computer software. So there's not a lot that you have to worry about. It's really plug and chug. Okay? Again, if you have any questions though, please feel free to contact me.